G'day everyone, Mark here. Just thought I'd give you a little update on a few things that are in the works. Yes, on the 12th of August, me and Tony went and paid for the filing. It's all sorted. It's now a counterclaim lodged in the criminal Manukau district, so we'll see how that works out. Case management hearing, as far as we know, still was the 9th of November at 11:45 at Manukau, so we'll see what goes on. But that's Police v Adams, not Adams v Police, which is the counterclaim. I will be releasing a separate video showing us actually doing that. Wouldn't you know it, the day me and Tony met up and got the memory sticks and got all the information and the video transferred over so they could all be handed a hard copy of the vid, we went in there and who wasn't there? Ben. Now what happened because Ben wasn't there? Nothing. We went in, our phones weren't seized, they were all having a little huddle there at the gateway. I cheekily asked if I was making sure I wasn't interrupting a staff meeting, and straight through, had to lift my feet because the buzzer went off, fuck knows why, and yeah, I just went and left my cell phones in the briefcase. So went through, no problems, no suspecting I was doing any harassment like Ben did last time. In fact, the mood had all completely changed. They were more than polite and nice. So I don't know, perhaps they're a little worried some civil suit may be coming, but I've got heaps of time for that, and I'm more worried about helping out Tony at the moment and various other people than little Ben and his infractions, although I will be letting the MOJ know to expect some legal filings. So we went in, reaffirmed his updating affidavit. The reason we did this is because when you're filing proceedings, you have to include a notice of proceedings, a statements of claim, and this is the grey area everyone's confused on. And there was another gentleman, Leroy, he knows who I'm talking about. He's also doing a civil claim at the moment, and what you must do is put in the affidavit with supporting evidence along with the notice of proceedings and statement of claim. Technically, the courts shouldn't be accepting it without an affidavit, but they do. And then they'll lead you on the path of thinking, oh, well, they've now got 12 months to respond to me. Well, the 12th month is just allowing the criminal case or the civil case or whatever the filing is you've done to time out. So you've paid them a filing fee, expecting a response, and yet the responding party doesn't have any affidavit or supporting evidence to respond to, so they won't respond, and you're left thinking, oh, well, they've got 12 months to respond, what happens if that doesn't happen? Well, you've just paid them money for nothing, basically. You have to file an affidavit, which is the reason when me and Tony went there on the 5th of August and first filed the affidavit, we filed an affidavit just simply saying that an updating affidavit will be coming in due course, because we needed to get the memory sticks to put the video on. And then we just filed the updating affidavit with the memory stick as evidence. The lady, because it was just a memory stick in a plastic bag, she put it in an envelope, put the exhibit note stamp on it, filled it all out, and then attached that to a piece of paper, and then photocopied it. Then she attached that piece of paper and stapled all of the other exhibits for all of the other parties, so everyone had a copy. It was really clever. I've since found what I should have done is just sellotape the goddamn memory stick straight to the piece of paper, marked it exhibit whatever, and that would have been sufficient too, and they can just put an evidence note stamp on it. But anyway, so that went through. We then paid the filing fee, $200, and that was brilliant. That all went through. They gave us, I mean, we already had the copies we needed, we just needed them to do the sign and stamp. They then gave us the receipt. So it's all been entered under the same CRI number as Police v Evans. So, because it's a counterclaim suit. So even if they decide to withdraw now, there's still a counter suit that has to be dealt with. They can't just withdraw and all of a sudden the countersuit vanishes. Alright, so that's one thing to look forward to. Too bad for them, I think. So we did all that, and then me and Tony sort of had a little chat and then decided to go wandering around to the police station. Now, of course, I had my body cam on, phone in the pocket, recording as well. It is not against the law to film in a publicly accessible area of a fucking police station. And if you get trespassed like Kiwi cameraman did in Rangiora or down Christchurch Way, no way is that legal. And I would suggest if you're ever trespassed from a police station, contact that police station and ask to have a conversation with them, and or have a meeting in person. Then when you're invited back at that police station, that invitation voids any trespass. Simple problem solved. But you can, under section 45B, I believe it is, of the Trespass Act 1980, you can legally trespass in cases of emergency, threat to property or person. So regardless, if you're going there for a court case, for instance, if you trespass from a court, you still have the right to be heard, right to justice, section 27(1) of the Bill of Rights. You still have to have access to the court. So as we saw with Paul Gray a long time ago in Hardware. So anyway, going on the beaten path, I'm just trying this new selfie setup I've got going on here with the camera, so hopefully you can see my ugly face better. But today what I'm going to do is I'm going to read out to you a very brief email exchange between me and our friend, the human Mike La, Sergeant from Manukau District Court. The one who got all uppity because he thought I said he wasn't human, when clearly, just like his listening skills proved with what I was saying about the jumper, he needs to get his ears checked. So this is what I sent him, and I'll put it up on the screen for you. I wrote to him, and this was to MLDW40 at police.govt.nz. You want the 6-digit QID and then just slap at police.govt.nz on the end of it, and there's your email address in case you need to contact them, or like I did, send them their 15 minutes of fame. So I sent on the 25th of July, just after 2 in the afternoon. Good afternoon, Michael. As you were unaware of the unlawful detainment to which I spoke of, which resulted in both Otahuhu and Manukau stations apologising after an IPCA complaint being upheld, along with your friend Scott Dixon lying on the incident report, here is a link to that. Hannah, HWJK72, which was her full QID, not JK72, unlawfully detained. So I've sent him the video of Hannah unlawfully detaining me for 20 minutes or 18 minutes at the cop shop. The IPCA complaint, because I like to be thorough. Then the phone call from Otahu, from the supervisor, I believe his name was Israel, who personally rang up and apologised for what Hannah had done, and they're now going to be using that as a training video, so he says. Fuck, I cracked up when he said that. And then a letter of apology from Manukau. So I've sent him the links to all 4 of those videos, so there's no, you'll find that about me. When I'm saying something, I usually have supporting evidence to back up every fucking fact I'm pointing out to you. So after that, as explained also to you on Friday, here is ASW842 and CHW, that's Cherie here, 263, assaulting and unlawfully arresting Tony at the airport. So I sent him a link to that one because he's unaware. Can't say you weren't told now, can you, Mike? And finally, as you took the Sergeant Schultz approach of I know nothing, perhaps after watching your pal Ben overstep, to which I will be filing a civil suit against him and the MOJ, or MDC, Manukau District Court, next time when being asked if you're detaining someone, I suggest your response not be, I can. Because that's what when I said to him, am I being detained? He goes, I can, but he wasn't. And then I walked straight out of the courthouse. I suggest your response not be, I can, which was uncalled for. Bear in mind that if you did, you may find yourself responding to defendant in a civil suit for breaching BORA Section 22. Remember Section 25 of the Crimes Act ignorance is no excuse, does not allow your ignorance of the law to be a defence. And if you're ignorant of the law, how can you enforce it? Good question that. If these cops don't know what the law is, how the fuck can they possibly enforce it? No, they'll just rather go out there, trample over everybody's civil fucking rights, and then say sorry for it after. It's such a democratic way. Don't ask permission first, just do it and then apologise afterwards. Here is your 15 minutes of fame from Friday, and I attach the link to that one, and I do hope you have a wonderful day. Warmest regards, Mark, one of those people, as you put it. Oh, you're one of those people. Charming fella, and you can see all the links of the videos I sent him. You might find the third link quite interesting. I attached the Terminator scene where he actually goes and shoots up the police station, because that's the only time I remember seeing a cop shop getting shot up. So yeah, that was that one. Then we can skip on to Michael's response, which I received. Oh, hello. Come on. You gonna get up here? Come on. This is Berian. Come on. Wow. He's my co-host. Oh shush. Just sit down and be good. He's hello. Daddy loves you. Right, so Michael sends me, good afternoon, Mark, Donald, Eric, Keane. Now I wonder how hard it was to figure out what my name was. Did you just do a little PNC check, did you? Or could it have been the channel link that I sent you being called CKA Mark, OTHO Keane? Varian likes to turn on the stereo. So perhaps, what? Perhaps that's what Michael, so cleverly devised from his investigation skills. I mean, police intelligence, total fucking hypocritical phrase that is. Good afternoon, Mark, Donald, Eric, Keane. Thank you for taking the time to email me. You're welcome, Michael. Hope you have a great day. Sergeant Michael La, Court Custody Unit Supervisor. So he must be based at the courthouse. And he still needed to ask the superior for questions, and he's a sergeant. You should know. And then this whole caution, this email originated from outside the organisation, yada yada yada, because they always do that. Oh, look out! It wasn't one of us emailing you, so look out. And my response to that brilliant, very thorough, warm felt email from Sergeant Michael La, I went, "You're welcome, Michael La, human." You may note on in the Friday clip, I show the email from the Ministry of Justice Senior Solicitor Chris Hurd from September 2018, showing the Ministry of Justice stating May 2018, showing the MOJ stating that the alterations I have done are acceptable to them. Should it be cold and I choose to wear my jersey at Manukau District Court again, I will ensure to have these with me, which I did. I would suggest that Ben Murphy fully read the Court Security Act 1999 or 1990 before enforcing sections of it again, as he failed to provide me with reasonable grounds to ask for my identification as per section 12(1)(c) of that act, and his discrimination against me will be redressed in the appropriate manner. Just as well you did not breach section 22 of 4 in 1990 with me, Mike. I would also like to thank you for not escalating the situation further and exercising your discretion, because you catch more flies with honey than you do with vinegar. Be nice. It's ironic that that's the name of Tony's business, Be Nice Builders. But I refer to the Roadhouse movie, Patrick Swayze, where he's telling all of these people how to be a caller. Escort them out the door, but be nice.
All you have to do is follow 3 simple rules. 1, never underestimate your opponent. Expect the unexpected. 2, take it outside. Never start anything inside the bar unless it's absolutely necessary. And 3, be nice. Come on. If somebody gets in your face and calls you a cocksucker, I want you to be nice. Okay. Ask him to walk. Be nice. If he won't walk, walk him, but be nice. If you can't walk him, one of the others will help you, and you'll both be nice. I want you to remember that it's a job. It's nothing personal.
Uh-huh. Being called a cocksucker isn't personal?
No. It's two nouns combined to elicit a prescribed response.
I wonder if somebody calls my mama a whore.
Is she? I want you to be nice until it's time to not be nice.
Well, how are we supposed to know when that is?
You won't. I'll let you know. You are the bouncers, I am the cooler. All you have to do is watch my back and each other's. Take out the trash.
You know, so that was my response to Mike, and that was the end of our little chit chat. I've also today just emailed from Tony's arrest yesterday on the 12th, sorry, on Friday. It's the 15th today of August. That the two officers that arrested him, or in fact IAGC 34, is not her QID number. Even though she said it really fast, quickly, and we slowed it down so we could hear it correctly, that is not her identifying information. And then she had the gall to turn around and say to Tony, I've just given you my name. No, you gave him a false QID number. Why is that false? Because I just tried emailing it and it bounced. Matty, MCF722, his went through. So I'm sure he can pass that on to his cohort. But I made sure I sent them the link of their 15 minutes of fame on YouTube as well, showing their unlawful arrest. Now, they always go on about this disorderly behaviour thing. Now, disorderly behaviour is creating a riot or a breach of the peace in public through your actions or actions of whoever. It's section 3. And they quote disorderly behaviour. But what they're meaning, and this is what happened with Tony, they said disorderly behaviour, but it's actually disorderly or offensive language in public. It's not disorderly behaviour. It's yelling or using offensive language, which Tony doesn't do. And I've spent hours now talking to Tony in the last few weeks. Not once has he ever sworn. He's a very Christian, God-fearing, loves his Bible, trying to turn a new leaf to what probably he used to be like to now. And not once have I heard him swear or even degrade people in any way, shape or form. But he won't put up with shit, and he won't take shit anymore. And I must commend him. The way he dealt with being arrested like that and just zipped his mouth, absolutely fucking perfect. That is what everybody should do as soon as they are under arrest. Demand for your rights to be read, because section 23 of BORA states that even if you are just detained or arrested, you must be read your rights. Okay? And then after that, zip it. You can see the frustration. You can hear Matty swearing, going on about David Gook or whatever his name is, the engine builder. I mean, these guys are still speaking in the earshot of public. They are committing disorderly behaviour by swearing in a public earshot, which is exactly what Matty did. So, you know, and this whole, you're going to be arrested for disorderly behaviour, that's the catch-all phrase they use. If you aren't swearing, and I highly recommend recording from the get-go any interaction with anyone, like Tony should have recorded, or at least had his camera on in his pocket, recording the entire interaction with David, which can prove that David made false statements to the police, saying that he was yelling and swearing and being abusive. We could do an RFI form into the police and ask for the communications and hear that 111 call that came in and see if David lied. Technically, Tony could then go and file a civil suit for fabricating evidence and making false statements, which are in the Crimes Act. But I mean, we all have bigger things to deal with. So yeah, there are lots of ways of dealing with it, but the way Tony dealt with it after he was arrested was beautiful. Put his phone in his fucking front pouch of his hoodie and got locked up. Stuck in a car for 20 minutes, and then the same idiot IAGC 34 that arrested him for disorderly behaviour without witnessing anything of that herself, then unarrested him, because that's what they do now. It's de-arrest, unarrest. We'll let you go. They should never have hooked him up in the first place. just lucky they chose not to process him. But then he's still got a complaint he can make against them now, because they weren't acting impartial. Why didn't they put David in handcuffs as well? You know, in the old days, the cops used to get both parties, hook them up until they figured out what the fuck the story was. But I guess that was breaching too many people's rights then too. They shouldn't be hooked up at all until they have evidence or have first-hand witnesses. And let's see David make a sworn statement to the police that Tony was swearing or cursing or whatever else. Would never have happened. Tony's just someone that stands up for his business partner and wants to see what they're entitled to sorted out, like the leaky roof, by the sounds of it anyway. And as the cop said, oh, it's a parking issue. Well, so it wasn't a call about disorderly behaviour then? Was it just a call about parking? You know, again, if we all had more time in our lives, I'm sure I could rip those pieces to shred as well, but I'm not going to. Anyway, enough of my 20-minute babble. That was the email to Mike La as far as the 5th of August is concerned. Sorry, the 22nd of July when we went there for the first thing and I was wearing my jumper. And I will be posting up soon the filing of the paperwork at the court and also the, well, I guess you could say serving notice of proceedings to the cops that assaulted Tony at Auckland Airport. And of course to the New Zealand Police, because they have to be named first. It's their organisation that they were representing. They also get named as defendant. Alright guys, see ya.